What if I tell you that even after proving all the points against the defendant, the plaintiff could not be able to get the compensation? Meaning thereby that the defendant, no matter has done all the wrongs against the plaintiff, even then plaintiff would not be able to get the compensation against the defendant. Yes, this could be confusing, but this is true. And the reason behind this is contributory negligence. Hello everyone, my name is Abhishek Singh and welcome to the Law of Torts lecture series. Today, in this video, we are going to talk about contributory negligence, that how, as we all know, that law of torts is all about twisted fact, and how in certain conditions, in certain issues, in certain situations, how the plaintiff, no matter the defendant has done all the wrongs, could not be able to take the compensation against the defendant. So, contributory negligence. Contributory negligence, here we are taking the definition of contributory negligence as causation. For example, in negligence, as the plaintiff has to prove that the defendant has the duty of care and that duty of care has been breached or violated by the defendant, and that breach has amounted to the injury of the plaintiff. Now, after satisfying all the three criteria, duty, breach, damage, there is a fourth criteria, and one of the most important criteria, that is causation. Causation means cause of action. What if that the duty, the breach of the duty has no relation with the damage? Or, for example, what if that plaintiff, the defendant, no matter has breached or violated his duty, but the damage which the plaintiff has sustained, he has sustained because of his own fault. The word itself defines that contributory negligence means what if the plaintiff has himself contributed to the negligence. As, for example, in many paternalistic law, for example, wearing of helmet or fastening of seat belt. What if I tell you that suppose Mr. X, who is driving a car, hit by a truck, and the truck driver was negligently driving the truck, he was hit by the truck. But unfortunately, Mr. X has not fastened her seat belt. Now, as Mr. X has not fastened his seat belt, he sustained injuries. The court will ask that who had the last opportunity, or because of whose fault Mr. X has sustained the injury. If Mr. X could be able to prove that the injury sustained by Mr. X is because of the truck driver's negligence, only then Mr. X could be able to get the damages. So, in a way, we are going to talk about what? The contributory negligence, the definition of contributory negligence, and how contributory negligence works. For example, there are certain situations where contributory negligence will be accepted and where not accepted. What if the court would not be able to find that who is at fault? Or what if there is a situation where 50% fault is on behalf of the plaintiff and 50% fault is of the defendant? Now, to this question, there could be three answers. For example, who caused it? There could be a possibility that the plaintiff would be able to prove that no matter the plaintiff was the contributor to the negligence, but the defendant, it is the defendant who caused it. The second answer could be that what if the plaintiff could not be able to prove that defendant caused it, rather defendant would be able to prove that it is the plaintiff who caused the damage to himself. Now the third answer would be neither of the parties could be able to prove, and the court found out that it was either of both the parties who contributed to the damage to the plaintiff. Now, coming to the first case, that what if the plaintiff would be able to prove that it was the defendant who has caused the damage to the plaintiff, then obviously plaintiff would be able to recover 100% of the damages. For example, in Davis versus Mann, very landmark judgment where the plaintiff who was negligent in fettering the forefeet of the donkey and he left his donkey on the highway, but it was the defendant who was running at the high speed on his horse cart, and he met with the accident, and because of the accident, donkey died. The plaintiff, the owner of the donkey, would be able to recover 100% of the damages. Why? Because it was the fault of the defendant that he was running at a very high speed and he could not see the donkey on the highway. The second case is, what if the plaintiff could not be able to prove that it was the defendant, rather defendant proved that the plaintiff contributed to his damage, to his injury. For example, in Butterfield versus Forrester, in this case, what happened was the plaintiff was running at the high speed and he met with an accident of the because of the pole installed by the defendant. Now the defendant is also negligent in installing pole on the highway, but it was the plaintiff who was running at a very high speed and he could not be able to prove that how it was the defendant's fault, as because the last opportunity is with the plaintiff that if he could have stopped at time, he could not be able to sustain the injury, and because of this fact, the plaintiff lost the case, and here the plaintiff could not be able to justify to the court that how the defendant acted here negligently and how it is only the defendant who contributed to the injury. The third would be if both the parties, for example, if both the parties could not be able to prove that it was the only negligence on the part of other party, then the third case would be applicable here, and here the apportionment of the liability will be seen. For example, the 2/3 liability or the 2/3 fault is with the plaintiff and 1/3 is with the defendant, then only the defendant has to prove 1/3 of the injury. For example, in rural transport service versus base number, what happened was the driver and the conductor both asked the passenger to sit on the roof. While the passenger was sitting on the roof, the driver took a sharp turn which resulted in the falling of the passenger from the roof and he sustained the injury. Here the court said that both the parties, the passenger as well as the driver and the conductor, were at fault, and now the passenger, who is the plaintiff here, will only get that portion of the damages where he could be able to prove that how the defendant, that is driver and the conductor, were at fault. For example, that means he could not be able to get 100% of the damages, but only those portions where he was not at the fault and the driver and the conductor were at the fault. Now let's talk about the rules of contributory negligence. That as in, what constitute the contributory negligence? The first rule would be that what the plaintiff negligence mean. Now, for example, that this plaintiff negligence, that is contributory negligence, should not be read in reference with the actual negligence, because in actual negligence we need to prove that how the breach happened and how the breach is connected to the damage. But in contributory negligence, we need not to prove, as it is just the defense of the defendant that why he should not be held liable for the fault. The second would be negligence. A plaintiff negligence must be operative. For example, there could be a possibility that plaintiff is negligent, but his negligence is working on a different tangent as different from the present case, or as different from the injury sustained by the plaintiff. The third would be test of prudent men. Test of prudent men means this third rule is very important with regard to whole of law of torts. Why? Because every time when we need to see that whether the person is at fault or not, we always use the test of prudent men. The test of prudent men tells you that how plaintiff acted reasonably or not. the fourth test would be test of alternative danger. The test of alternative danger means what if the defendant has created a situation, a dangerous situation, where the plaintiff acted extraordinarily or acted which a prudent man or a reasonable man would not have acted, but he acted. Why? Because of the alternative danger involved in it. So these are the 4 rules. Now starting with the first rule, what the plaintiff negligence mean? Here, the negligence of plaintiff should not be, I have already told you, should not be read with the line of the actual negligence, where we need to prove that duty of care is there. Breach of that duty is there. And here, the second case would be in the second rule is Jones versus Levox queries. Jones versus Levox queries is basically regarding that plaintiff's negligence must be operative. That means the plaintiff negligence and the negligence involved must be coincide, must be in same tangent. For example, in this case, what happened is the plaintiff was negligently driving his motorbike on the road because of the faulty brake. But the incident happened because of the negligent act of the defendant, where he was shooting negligently and one of the shot got hit by the plaintiff. Here, the defendant asked because of the asked for the contributory negligence. Why? Because the plaintiff was negligent while driving the motorcycle. The court said the plaintiff being negligent while driving the motorcycle and the defendant being negligent while shooting are operating in both the different tangents, and here the negligence of the plaintiff won't count, and this is not the case of contributory negligence. Now the third rule is test of prudent man. Here in this case, the case would be, for example, the rural transport case, which I have already told you. For example, in this case, the rural transport case, as the passenger was asked to sit on the roof and he also agreed to sit on the roof, he has also contributed to the negligence and he did not act prudently. Hence, this rule will be applicable, and the passenger contributed to the negligence, and it is a case of contributory negligence. Now, the fourth would be test of alternative danger. What if the defendant created such a dangerous situation, where the action of the plaintiff should not be judged on an ordinary basis, on a reasonable basis, on a prudent basis. Why? Because the defendant himself has created such a dangerous situation that there was no option behind the plaintiff to act. For example, in Kesorchi Ishwar versus GIP Railway, Kesorchi Ishwar versus GIP Railway is a case where the plaintiff, while the defendant did not stop the train on the platform, the plaintiff jumped out of the train and he sustained injury. Since he sustained injury because of the jumping, the defendant said that who had the last option was with the plaintiff, and because of his own jumping, he sustained injury. Defendant wouldn't be held liable. This is the case of test of alternative danger, and since the situation is such that the plaintiff had no option but to jump, and this is not the case of contributory negligence, but this is the case of test of alternative danger. And because of the alternative danger, so that he could not be able to hit, because if he could not have jumped, he would have missed his platform, and because of this, the case won't be called as contributory negligence. Now with this, we have come to the last part of our lecture, that is what if we have already talked about much, that test of last opportunity. I have time and again repeated that who had the last opportunity. So the test of last opportunity has been evolved from case to case basis. For example, it all started with whether the plaintiff contributed to the injury or not, and if the plaintiff has contributed to the injury, even if the defendant would be able to prove that the plaintiff has contributed to the injury, the plaintiff will not get the compensation, and no matter he has sustained injury, unfortunately, the defendant would be scot-free. But the test of last opportunity is giving another chance to the plaintiff to prove that who had the last opportunity, as in to avoid the incident. For example, in Davis versus Mann, no matter plaintiff was negligent in leaving his donkey on the highway, but who had the last opportunity? The last opportunity is on the defendant, because he was driving at a very fast speed, and because of his overspeeding, he met with an accident, and because of the overspeeding, the accident happened, and who had the last opportunity to avoid? It was the defendant who had the last opportunity to avoid. The opportunity was done in British Columbia Electric Company versus Loach, where the constructive test of last opportunity was applied. Here the constructive test of last opportunity would be, for example, the prima facie test of last opportunity was not with the defendant, but it is becoming because of the negligence of the defendant. In this case, what happened is, the defendant, who was the tram driver, he was driving a train, and as he was driving the train, he saw the truck coming. As he had the last opportunity to apply the brakes and stop the train so that to avoid the accident, and when he started applying the brakes, he found out that because of the defective brake, he could not be able to stop the train, and hence the train met with an accident with the truck. In this case, the test of constructive last opportunity is seen as prima facie last opportunity is not with regard to the train driver, but it constructively becoming the last opportunity. Why? Because of the negligence of the defendant, of the train driver, because when he applied the brakes, he found out that because of the faulty brake or defective brake, he could not be applied the brake, and as the last opportunity now shifted with the train driver to avoid the accident, and as he could not be able to avoid the accident, and he had the last opportunity, he was found guilty. With this, we have come to the end of the discussion video. Thank you so much.